Hello, my name is Charles Ward. I'm a staff attorney for Alaska Legal Services Corporation. And today I'm going to be giving a brief overview of forcible entry and detainer, often called F.E.D hearings. These are the hearings that follow once a landlord, usually a landlord, has filed a lawsuit against a tenant, asking the court to grant the landlord possession because the tenant is, in the landlord's view, illegally possessing the property. So there's two parts to a F.E.D proceeding. The first part is the possession phase, and that's the part that I'm going to be spending most of my time on today. The damages phase I'll talk about a little bit because there's some special statutory damages that are available. But generally, the damages phase is like any other civil hearing with normal deadlines, normal discovery periods, things like that. So it's not substantially different than a typical civil case. So that's the other type of hearing, or that's the second part of the hearing there, the damages phase. So in a possession hearing, it's a summary proceeding. So it happens very quickly after the time the landlord files his initial lawsuit, and that he files the initial lawsuit seeking possession and seeking damages. So it's a summary proceeding. It's designed to make a quick determination on possession and possession only. It doesn't get into other issues that a landlord and tenant might find themselves involved in, such as damages or a landlord's failure to do certain things or a tenant's failure to do certain things. And the reason it was set up this way as a quick determination was to cut down on both a landlord's use of quote unquote self-help. That means things like locking the tenant out or going in and throwing the tenant's possessions on the front yard or shutting off utility services or stuff like that. That's, of course, something a landlord is not allowed to do under the law. And this is designed to help encourage landlords not to do that, because they know if a tenant is illegally possessing the property, they can get into court and reclaim possession in relatively short order. Also designed to cut down on violent confrontations, either when a landlord goes over to confront a tenant about staying over illegally, or a landlord tries to engage in self-help, or a tenant tries to discourage a landlord from doing things that perhaps not in a legal or right manner. The summary proceeding is usually within 1 or 2 weeks of the suit being filed. Maximum under law is 15 days unless the court finds good cause for there to be an extension. Beyond that, my experience is that you'll have your hearing within 15 days at the outside. It's usually more closer to a week to 10 days. The defendant, who's usually the tenant, not always, but usually, can request one continuance for cause. They have to show why they need it, but that can be, I need to hire legal counsel, or I need to consult with legal counsel, or I can raise a defense to this, but I need time to get my evidence together, what have you. But that continuance is only for 2 days, unless the tenant or the defendant can post a surety to the landlord for the landlord's potential loss of rent for the period of continuance. So if the tenant requests a continuance for a week or 2 weeks, he or she would need to post a bond or some other kind of surety to show that the landlord is covered for the landlord's potential loss of rent during that period of the continuance. Generally speaking, the landlord, the plaintiff, can request continuances for cause. Obviously, the court is not going to continue something indefinitely, but at the same time, usually if you're bringing a case saying you seek possession and then you want to continue, the other side is not going to give you any problems over that, because they're going to want to probably try to keep possession as long as they can so that they can either make their own defenses or, in the alternative, find different housing, knowing that they may lose their house or their apartment or what have you. Even though the hearing is usually within a week to 10 days, again, a maximum of 15 days, the defendant must be served at least 48 hours before the hearing. So you'll need to return service or show the court return of service and show that that happened at least 48 hours before the hearing began. So if not, the court may dismiss the case. Usually what it'll do is just continue it until the plaintiff can prove that the defendant has been served. Of course, just like any other civil suit, the plaintiff, usually the landlord, has to prove that he or she is entitled to possession by preponderance of the evidence. So that part, it really isn't all that much different than a civil suit. Of course, the major difference is in a week to 10 days or 2 or 15 days, even, you're not going to have time to do the normal discovery and interrogatories and things you would normally do in a civil suit. So you have to be able to make your case you need to be able to make your case probably at the time of filing. So you can introduce evidence such as an account ledger or evidence of intentional damage through pictures or videos or what have you. Again, evidence of illegal activity, whether that's through pictures or video or perhaps a police report or something like that, or any other evidence you might have that shows that your client, who is the landlord, might be entitled to possession. A defendant's defenses are limited in an F.E.D. hearing, simply because this isn't about damages or other issues of landlord-tenant law. This is simply to decide who is entitled to possession. Some of the defenses that you can raise, of course, are one, that the landlord violated his or her duties under the Landlord-Tenant Act, that the landlord is filing this case in retaliation for the tenant exercising his or her rights either under the lease or under the law. That is by telling the landlord, hey, our lease requires you to do this and you're not doing it, or hey, landlord-tenant law requires you to do certain things or prevents you from doing certain things that you're doing or not doing, and you need to stop. And even if and of course, usually what happens if there's going to be retaliation, the defendant has gone to either speak to an attorney or some government authority about the issues he is having with the landlord under the lease or under the Landlord-Tenant Act. So an eviction hearing can't be filed in retaliation for that. Now, if there's a purpose other than retaliation, and retaliation is just kind of a side effect, for lack of a better term, then usually the case will proceed. But if there's solely a retaliatory purpose, then that is a good defense against an F.E.D. Discrimination, of course, Fair Housing Act lays out certain elements of discrimination, discrimination by race, discrimination by gender, other illegal methods of discrimination. I'm not going to dwell or dive deep into the Fair Housing Act at this point, but if you believe your client has been discriminated against, or there's reason to at least look into that, then the Fair Housing Act and the rules under that Fair Housing Act would certainly be worth looking into and raising as a potential defense if in fact they apply. You can simply say the plaintiff didn't meet his burden of proof. The plaintiff does have to prove, again, by preponderance of the evidence, that he or she is entitled to possession. And if the plaintiff does not do that, and then of course you can just simply make the argument that the plaintiff hasn't shown that he or she is entitled to possession. Some of the other defenses available to you: improper service, that your client was never served properly and didn't receive service in time. That's probably not going to get the case dismissed, but would at least probably allow it to be continued for a few days until service can actually be done, or that the plaintiff can show that service has actually happened. And one other defense available to you is an effective notice to quit. We have a separate training that covers notices to quit backwards to forwards, so I'm not going to dwell too far into the weeds on what exactly needs to be in a notice to quit, and also what types of notices to quit need to be posted given different scenarios. I would certainly invite you to watch that training that's been done elsewhere to get a more in-depth overview of those, but I'll go over a few things that you as an attorney for a tenant might want to know about a notice to quit. They're strictly construed, so the notice what is in that, there are certain elements laid out in law that a notice to quit has to have, such as the notice of the violation or the other reason that the tenancy is being terminated. So you haven't paid rent, and this is how much rent you haven't paid. You are conducting illegal activities on the property. You have intentionally caused damage to the property, what have you. needs to say those things it needs to lay those things out in detail, or if it's just simply the termination of a month-to-month tenancy. Some violations of lease, such as non-payment of rent and certain other types of violations, are curable by the tenant. So if it is a violation that can be cured by the tenant, then the notice to quit has to provide a sufficient opportunity for the defendant to cure that by either paying rent or fixing the nuisance problem. If it's something like not taking the trash out or something like that, the defendant would be able to usually would have an opportunity to cure that sort of violation. Notice of when the defendant has to leave. So I'm posting the notice on this day. You have this many days to get out, and that time span has to comply with the law, and as requires the notice requirements. Again, the separate training on notices to quit will go into greater detail as to your scenarios and how much notice is necessary, but it does have to give notice of when the defendant is supposed to leave. If the issue is past due rent, then it needs to accurately reflect how much rent is past due, and it's rent only, cannot include late fees, service fees, any other fees along those lines. It's just rent and rent only. One other thing to know about on a notice to quit that wasn't listed there is that if a notice to quit doesn't give notice to the defendant that if the defendant doesn't either cure the violation or move out within specified time, the landlord will seek to file an F.E.D action civil suit in court. The notice to quit does need to contain that as well. The ways you can serve a notice to quit: by posting. That's simply going to the door of the property and taping it to the door, and taping it securely so it doesn't blow away or what have you. If the posting is, if you know for a fact that the tenant, say, uses the garage door to enter the property instead of the front door, you as a landlord probably should post as both the front door and the door that the tenant uses. You can do it in person, just simply handing it to the tenant, saying, here's your notice to quit. You can read it and ask questions if you need to. You can leave it with a responsible person, which is going to be the same thing as it is in a normal civil suit, someone over age who seems to be a reasonable responsibility who's at the premises. You don't have to use a process server, so the landlord can do that personally, or have his or her property manager do that. You can also send it certified mail. This usually does not happen because to show proof of service, of course, you're going to need to show the court that you got that green card back, and that can take a long time. And if the tenant doesn't sign for it, you may be in a situation where you have to either do service by another method or ask for alternate service. But certified mail is an appropriate method of use of service if you choose to do that. Perhaps you're a landlord who lives out of state and you don't have anybody there to do service by any other means. If you do use certified mail and the tenant has moved out, then you need to be sure that you either send that notice to the tenant's new address, or if you don't know it, you need to take reasonable steps to obtain the new address. If you have the tenant's phone number, you need to give the tenant a call. If you know where the tenant works, you need to call the work and say, even if you don't talk to the tenant, hey, so-and-so needs to get a hold of me. You can also try sending it to that former address and see if the post office will forward it. But again, that's just going to make the delay even further, and less likely that you'll actually be able to demonstrate service that way. So again, that's why certified mail usually is not used for service, but it is an availability. Certain things that you will not have at an F.E.D hearing, at least the possession phase. You don't argue about damages. Damages are done later on, and it's under a normal civil under normal civil rules, with a few exceptions that we'll talk about here towards the end. If the landlord didn't previously notice an issue, so say a tenant is behind on rent, but also is failing to take the trash out on a regular basis, and the notice to quit is only for non-payment of rent. Well, if the tenant has cured that problem but hasn't cured the trash problem, you can't just at that court hearing, you can't just simply raise that as another reason to evict the tenant. You would need to go back, post a new notice to quit, and say why you're doing it. That would be because of the nuisance problem or the trash problem or something like that. You don't usually see these types of arguments, but every once in a while you may see an issue. The title comes up. Who properly has title to the property? Again, that would not be something that would be argued at a F.E.D hearing. That would be something that would require civil, a full civil case to move out to play out. If you are representing a defendant and a tenant, and he or she happens to lose, they have usually a minimum of 48 hours to get out under the law. The judge will usually extend that if they are minor children at the house. In fact, the judge should extend it if there's minor children, or if the tenant's in the military, or if there's other good cause to extend it beyond 48 hours. But your client is probably not going to, even in the best case scenario, get much more than a week. So if you lose, your client needs to be ready to get out in a hurry. It needs to have a backup plan in case the court case does not go in his or her favor. What will happen if the defendant doesn't get out in 48 hours is that at the hearing, the landlord will ask, or the landlord's attorney will ask the court to issue writ of assistance, which will authorize, if the tenant is not out at the time specified by the court, will authorize the police, whether that's the local police or state troopers, depending on where you're at, to go over and enforce the order and basically require the tenant to get out. And usually the police will give you 15 minutes or less to get out once they have to go enforce something. Now, given police priorities and other things, if your tenant's supposed to be out in 48 hours, police are probably not going to show up at 48 hours and 1 minute, but they can pretty much show up at any time and make the tenant get out. So if your tenant does lose, he or she would need to be able to get out and get out quickly. So that goes over a little bit more of the police enforcing that court order. For damages, there are a few statutory damages available, but otherwise it's essentially a civil case. The difference is, of course, you may have the possession hearing before the answer is due. Normally you have 20 days to file an answer, but the possession hearing is probably going to happen in sooner than 20 days. So you may be in an unusual position of having an argument over possession before you file an answer, which is pretty common in forcible entry detainer proceedings, but obviously not very common in other proceedings. There are certain statutory damages available both to landlords and tenants in a damages hearing. First off, if the landlord is shown to have filed the F.E.D for retaliatory purpose, the tenant can claim 1.5 times his or her actual damages. If the landlord is engaged in unlawful lockout, this is the self-help we referred to earlier. Again, the tenant can claim 1.5 times his or her actual damages that he or she suffered by the lockout. So if the landlord went in and threw stuff on the lawn and some of that stuff was ruined, those would be damages. If the tenant had to go find a hotel to stay at, those would be damages they would not normally have had to incur. Same thing about willful utility shutoff. That's essentially considered a lockout, and tenant would be able to claim 1.5 times actual damages. Now, this is not if your tenant doesn't pay the utility bill and it's shut off, or the tenant is supposed to pay the landlord and has not done so. This is the landlord's like, I need to get that guy out, so I'm going to go shut off his water, or I'm going to shut off his power, and there's no other reason for him to do so. If a landlord generally has a right of entry has a reasonable right of entry into the premises. And I'm not going to get into too far into what is reasonable and unreasonable, but usually they have to give notice of at least 24 hours, and they still cannot force their way in regardless of whether the tenant gives permission or not. If they give notice and the tenant denies permission or denies access, the landlord's remedy is to go to court and get an injunction requiring the tenant to give access. So if the landlord is entering unreasonably, not giving notice, just walking in, or is coming in, 2 or 3 times a day, then that would be those could potentially be unreasonable entries. And in that case, the tenant would be able to claim either 1 month's rent or actual damages. Of course, damages may be hard to prove in that scenario. So that's why the law allows for 1 month's rent. The other statutory damage that may be available to a landlord is if the tenant stays beyond the date they provided. So a tenant says, "Hey, I'm going to move out on June 1st," and this is if the lease is up and the tenant's ready to move on and gives 30 days notice that they're going to move on and says, "I'm going to be out June 1st," but he or she doesn't actually move out by June 1st. Then the landlord would be able to sue or claim 1.5 times damages, basically for the unpaid rent and then any loss they may have had and that they've rented the property out to somebody else and they're not able to enforce or not able to give them access to the property like they would be required to under the new lease. One big difference is a successful party in a landlord-tenant case is usually able to seek full attorney's fees. They're not limited by the Rule 85 of Rule Civil Procedure. I'm sorry, not Rule 85. They're not limited by the rules of civil procedure. There's a schedule laid out in the rules of civil procedure for attorney's fees that you would normally be bound by. But there's a Supreme Court case, Dawson v. Timonson, and there's the citation listed there on the screen, which basically says that the way the Supreme Court interprets the Landlord-Tenant Act is that full attorney's fees are available. So you can obviously ask for that in a court case if you end up being the winner, but that can also be very useful to use in negotiations if you believe you have a good case and want to discourage the other side from either pursuing the case or taking it all the way to court. So that is a general overview of forcible entry and detainer. Hopefully this is a little bit helpful. Of course, just like with anything else, some of it is, these are questions. Sometimes your case will have very specific things that aren't necessarily covered here, and you would need to do more research. So this is intended to be a general overview and not necessarily specific to any one case or action. Again, my name is Charles Ward with Alaska Legal Services, and thank you for your time and attention.